My name is Peter MacDonald Eggers. I'm a barrister who specialises in the practice of commercial law, in particular insurance, shipping and international trade law. I will be providing you today with an overview of the course on marine insurance law. Now, the law of marine insurance is an ancient one and, as far as I'm concerned, is endlessly fascinating, but more importantly, it's a vital part of English commercial law and, for that matter, international commercial law. The importance and interest of marine insurance law lies in the following four considerations. The first is that academically it's both interesting and challenging. Secondly, it's of extraordinary practical commercial importance, and that's because many, if not most, commercial transactions involve insurance, and insurance is there to guard against things going wrong. As a result, many insurance law problems, particularly those of marine insurance law, arise when there are disasters, often tragic, often very sad, and they affect not just particular cities or countries, but often nations as a whole. The types of cases where insurance problems occur may result from armed conflicts, international armed conflicts or civil wars, piracy, terrorism, but natural disasters such as earthquakes and hurricanes or fires, as well as extraordinary and massive commercial declines. And it extends to all types of human behavior, from mere accidents to fraud. The third reason why marine insurance law is important is because it serves as the foundation not just for the law of marine insurance, but also the law of non-marine insurance. And finally, the law of English law of marine insurance is a law which has influenced the development of insurance law, and in particular marine insurance law, in many other countries. So it's a very important subject, and as a result, it's a subject I'm very passionate about. And hopefully you will discover the interest and passion of the subject whilst you undertake this course. Now, the law of marine insurance is derived from two principal sources. The first are the cases. These are the decisions of the judges which have been made over the last 3 or 4 centuries, although it's fair to say that the critical cases really started to develop during the latter part of the 18th century with the decisions of Lord Mansfield, who was the Lord Chief Justice of his day. The second source of law is that of the Marine Insurance Act. Now, that is an act which was passed in 1906, and it was drafted by Sir Mackenzie Chalmers, and he undertook the Herculean task of considering all the cases which then existed on marine insurance law, which he numbered around 2,000, and reviewed each of the cases, analysed them, and extracted from those cases the relevant legal principles, which he proceeded to codify in the Marine Insurance Act. Accordingly, the Act can be regarded as a codification of the case-made law, or if you like, the common law, as it stood in 1906. Now, since then, there have been many, many more cases which have developed the law and interpreted the Act. Now, in order to undertake this course effectively, you will have to review the principal cases, not all the cases, because that's a very tall order, but the principal cases in order to extract the relevant legal principles, but also to become very familiar with the 1906 Act itself. It's not a very long act compared to many other statutes. It's not more than 100 sections, and some of those sections are very short. So it's entirely achievable, but a mastery of the Act is a very important starting point for developing your skills in marine insurance law. I should point out that the law of marine insurance, indeed the law of insurance, is undergoing an internal legal review at the moment, not just within the government, but also with the Law Commission and many other external agencies, with a view to reforming the law, because there are some aspects of English marine insurance law which are treated as harsh, particularly towards one of the parties, the assured, as opposed to the insurer, and it's prompted this call for law reform. But this has been an ongoing process Now, whilst that process has developed a change in consumer insurance law as of last year, the discussion and debate concerning commercial insurance law is still ongoing. So it may be many years yet before there are any changes to the law, although it's possible that the change may come sooner than I think. Now, each of the sections of the marine insurance law course, of which there are 4, is introduced by a chapter which identifies the aims and objectives of each of those sections. Now, I say there are 4 sections. The sections are as follows. Section A is concerned with the contract of marine insurance and identifying what it is and what it means. The second section, Section B, is concerned with the duty of the utmost good faith and the position of the assured and the insurer in relation to the risk presentation process, as well as the assured's agent, the broker. The third section, Section C, is concerned with the manner in which the contract of marine insurance works by reference to notions of dangers or perils, causation, and also the terms of the contract itself. And finally, Section D is concerned with principles of indemnity, of contribution and subrogation, as well as considering the rights of third parties. It's important to understand each of these sections in order to understand the whole of marine insurance law, but each of these sections can also be studied independently to provide you with a focus on the particular topics to which each of the sections relates. Now, once you've considered each of these sections, as I say, hopefully you've mastered the topic and you will begin to discover that marine insurance law is not only important to both international trade and global finance, but also endlessly fascinating. So I hope you undertake this course with a view to discovering the delights of marine insurance law and find it as interesting as I already do. I hope that is of assistance.